We are here for the annual Alexander Meiklejohn Lecture, which is sponsored under the guise of the Taubman Center for American Politics and Policy, which is housed now in the Watson Institute, has been for a couple of years. Alexander Meiklejohn the lecture was named for civil libertarian, Brown alumnus, and former Brown dean, Alexander Meiklejohn, and focuses on the theme of freedom and the U.S. Constitution. Meiklejohn graduated from Brown in 1893 and served as its dean from 1901 to 1912. Notice there's nothing after that, dean of, just dean. That's what Brown's size was then. Supreme Court Justice William O. Douglas delivered the first Meiklejohn lecture in 1963. In the last 20 years, other speakers have included Stanford Law Professor Michael McConnell, National Public Radio legal correspondent Nina Totenberg, University of Chicago Law Professor Martha Nussbaum, Berkeley Law Professor and Dean Christopher Edley Jr., and today we have the great privilege of hosting Justin Driver, who is Brown alum, class of 1997, and also took my class, Congress and Public Policy, the first time I ever taught it. So you can ask him, and he can tell you how I was, because I don't even remember how I was. But it is amazing to see generations of Brown students leave and excel, in particular the way that Justin has. But it really gives me great pleasure to have him here, giving the Alexander Meiklejohn Lecture this year. So he has a very accomplished bio. I will try to get all of it in with the time that we have. Justin Driver is the Robert R. Slaughter Professor of Law and Counselor to the Dean at Yale Law School. He teaches and writes in the area of constitutional law and is the author of The Schoolhouse Gate, Public Education, the Supreme Court, and the Battle for the American Mind. The book was selected as a Washington Post notable book and editor's choice of the New York Times Book Review. It also received the Stephen S. Goldberg Award for Distinguished Scholarship in Education Law, among other things. Professor Driver is also the recipient of the American Society for Legal History's William Nelson Cromwell Article Prize. He has a distinguished publication record, having published in academic and law school journals and Slate, The Atlantic, New York Times, Washington Post, The New Republic, where he was a contributing editor. We can go on and on. An elected member of the American Law Institute and of the American Academy of Arts and Sciences. He's also an editor of the Supreme Court Review. In 2021, President Biden appointed Driver to serve on the Presidential Commission on the Supreme Court of the United States. Professor Driver's previous appointment in the law school at the University of Chicago, and he's a graduate of Brown, Oxford, where he was a Marshall Scholar, Duke, where he received certification to teach public school, and Harvard Law School, where he was an editor of the Harvard Law Review. After graduating from Harvard Law School, Professor Driver clerked for then Judge, now Attorney General, Merrick Garland, Justice Sandra Day O'Connor, and Justice Stephen Breyer. So, a lot to live up to, you Brown students in the room. So I welcome Professor Justin Driver for his talk, Schooling Free Speech. He'll talk for about 40 minutes, and then we're going to open it up to Q&A, and we welcome your questions. So, Professor Justin Driver.
Okay, I'm really delighted to be here. Thank you so much for that incredibly generous introduction, Professor Schiller. It's wonderful to be back here at Brown. This is, without doubt, the formative intellectual community of my life. Brown is a wonderful place for many reasons, including because it seamlessly blends the dynamism of a first-rate university with the intimacy of a liberal arts education. And that is attributable to wonderful professors like Professor Schiller and Professor Ross Chait and Professor James T. Patterson, who I was lucky enough to have lunch with today. Okay, so I'm now going to, I should say as well, I am particularly honored to be here to talk about, to deliver this Meiklejohn Lecture. Meiklejohn is a luminary in the free speech world. People pay a lot of attention to him. He is known for fusing this idea that the freedom of speech is connected to democracy. He believes that self-government is intimately connected with the First Amendment. So it's impossible to overstate the significance of Meiklejohn in the First Amendment. So that was
we're gonna apologize for a technological glitch.
Oh.
And we're just gonna shut this because this is not what we want. And we're gonna ask Professor Driver to start again.
Okay,
Thank you so
really take it
much.
from the top?
No, middle, you know.
Okay, all right.
Meiklejohn.
I'm really glad to be here. Okay, so Meiklejohn, so important. Happily, not all of his ideas gained traction. When he was a student here, he wrote an opinion piece for the Brown Daily Herald, the BDH, and he came up with this idea where he said that anyone who has 6 unexcused absences should be immediately expelled. Immediate expulsion. I am so glad that that idea did not take heed. Otherwise, I would not be a graduate of this fine institution, I can assure you. One of the things that makes Meiklejohn so important, though, is that he believed that showing up was truly important, and you all have shown up today. And it is connected to his First Amendment ideas. One of my favorite quotations from Meiklejohn is the following: "Democracy is the art of thinking independently together." Democracy is the art of thinking independently together, that we have a lot to learn from each other, so showing up is important. Okay, so what I'm going to do today is to discuss schooling free speech. This is an outgrowth of my book called The Schoolhouse Gate, which offers a panoramic look at students' constitutional rights. I have chapters on the freedom of speech. I have chapters on the quest for racial equality in schools, thinking about Brown versus Board of Education. I have a chapter on criminal procedure. I have a chapter on discipline in the form of suspensions and corporal punishment, which exists in this great nation of ours. But given that this is the Meiklejohn Lecture, I felt compelled to speak about the importance of free speech. For a long season, the dominant view was that courts had no role whatsoever to play in resolving disputes between students and school authorities. The notion was that judges are not teachers, and therefore they are ill-equipped to be able to engage in this arena. Slowly, the Supreme Court grew to recognize that it would be a mistake to treat public schools as free speech zones. And they began to import at least some semblance of First Amendment values into our public schools, or, as I think of it, schooling free speech. That topic has been one of the most vexing and challenging and at times incendiary tasks in modern constitutional adjudication. It involves questions of patriotism, racial equality, illegal drugs, teen sexuality, and lots of profanity. What I'm going to do today is to try to offer the public school as a site of constitutional interpretation. It seems to me that the Constitution assumes a particular form in the nation's public schools, and that it's different, the rights that minors have when they are in public schools than when they are in the public park across the street after school. And that we can learn a lot by paying attention to the school as a particular theater of constitutional interpretation. And what the court has done in this arena, as in so many others, is to offer what might be regarded as junior varsity constitutional rights. Students don't have the full-fledged array of constitutional rights that exist in non-school settings, but they do receive some constitutional protection. And one of the sort of tensions here in this area is that justices believe that schools are creating citizens. Just about all of the justices believe in that notion. but they have radically different conceptions about what sort of citizenship is involved here. And so there are two sort of dominant conceptions. One might be the robust conception of citizenship, a rather thick conception of citizenship, where students should be mixing it up, and democratic society in the United States is known for people communicating, contrasting views, and that it would be a mistake to diminish that conflict in our nation's public schools. So that's the thick conception, sort of a Tocquevillian notion, and indeed a Meiklejohn notion of people disagreeing and thinking independently together. That's one thing. But there's also a thin conception of citizenship, what I sometimes think of as the report card conception of citizenship, where some of us, when we were in grade school, received a grade on our report cards, thinking about obedience, sort of paying attention to others, playing nicely with others, sort of an emphasis on conformity and things of that nature, right? Not creating a disturbance in the class. And so it seems to me that it's those two battling conceptions of citizenship that is often at work at the cases that I'm going to discuss today. I should lay my cards on the table that I am more sympathetic to the thick, robust conception of citizenship in this free speech area, though I do not adhere to that view in all instances, and I will talk about one case at least where I depart from the traditional left liberal orthodoxy on these questions. Okay, so I'm going to talk about a few different cases. The first of them is the Barnette versus West Virginia case from 1943. This is a case that involves whether it's permissible to require students to pledge allegiance, recite the Pledge of Allegiance to the American flag upon penalty of being expelled for refusing to do so. This case first arose at the court in 1940 when Jehovah's Witnesses were expelled for refusing to recite the Pledge of Allegiance. They regarded it as infringing upon their free exercise rights. They cite Scripture, Exodus 20, which prohibits the worshiping of graven images. And they say, I cannot, consistent with my religious scruples, recite this Pledge of Allegiance because, in effect, the flag is a graven image for them. In 1940, Justice Frankfurter writes an opinion for the court, and it's this thin conception of citizenship that is at work there. He says, national unity is the basis of national security, right? We're not going to get involved in this arena, Frankfurter says. He says, the courtroom is not the arena for debating issues of educational policy. So to hold would in effect make us the school board for the country. This was meant to be a horrific idea, right? The school board for the country. That's not what we're meant to be doing. So it seems to me that Frankfurter's view is that judges should mind their own business and leave educators to the business of molding American minds. This decision in 1940 set off a raft of violence that was visited upon the heads of Jehovah's Witnesses all around the country, from Maine to Mississippi. And there were, at the time of the Go-Bitis decision, schools in 15 different states that were expelling students for refusing to recite the Pledge of Allegiance. But by the time that this issue made its way to the court again 3 years later, schools in all 48 states at the time were expelling Jehovah's Witnesses. And when the case makes its way back, or when this issue makes its way back to the court in the Barnette decision from 1943, it's Justice Jackson who writes the opinion for the court. One of my favorite opinions in all of constitutional law, perhaps my favorite. Another Barnette fan here. Jackson reconceptualizes the right at issue as involving not the free exercise of religion, but instead the freedom of speech. Justice Jackson says that the freedom of speech involves a corollary negative right, the freedom not to speak, and that there's a prohibition on compulsory speech in this nation. Jackson has many soaring, memorable lines. Here's one. He says, if there's any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox, right? That it is, in effect, we can understand him to be saying, un-American to require people to pledge allegiance to the United States flag. And here he has a thick conception of citizenship. He says, Jackson does, that public schools are educating the young for citizenship is reason for scrupulous protection of constitutional freedoms of the individual. If we are not to strangle the free mind at its source and teach young people to discount important principles of our government as mere platitudes, right? It's a very evocative statement about strangling the free mind of it at its source. If we don't honor constitutional protections at the schoolhouse, Jackson suggests, then our young people are going to think, the Constitution, just some piece of paper, neither here nor there. So we dare not shirk our duty within the school. Flash forward to the 1960s, the most famous case in this area is decided in 1969. It's called Tinker versus Des Moines. And here we're thinking about students in Des Moines, Iowa, who want to wear black armbands to school in protest of the Vietnam War. School officials get wind of this plan and they say, oh no, that is too hot of a topic. We have had a graduate of Des Moines High School who died over in Vietnam, and his buddies are still around here. And if you wear these black armbands, his friends are going to take you as dishonoring his memory and indeed his sacrifice for this nation. And so in order to keep the peace, you cannot wear these black armbands. The Tinker children, Mary Beth and her brother John, among others, decided to wear the black armbands, and they miss several days of school before they agree to relinquish wearing the armbands. And they bring a lawsuit. And this is, of course, different than Barnette, which involved the right to remain silent, in effect, right? The right to be quiet. And Tinker raises the question of whether there's an affirmative right to speak up and to announce your views. The Tinkers paid a tremendous sacrifice for wearing these armbands. They were sort of outcasts in Des Moines. They were accused of being communists because only a communist would dare to oppose the Vietnam War. We should say that this is in December 1965, long before the rise of mass mobilization against the Vietnam War. The Tinker household was pelted with sort of harassing phone calls, nasty letters, and a bucket of red paint was taken and splattered on the front door of the Tinker household. The evident implication is that only a communist, a red, would dare to oppose the Vietnam War. It's an open question as to whether the students had constitutional rights to sort of announce their views. Justice Fortas wrote the opinion for the court, and he gives me the title for my book. He says, "It can hardly be argued that students shed their constitutional rights at the schoolhouse gate." Right? Nice line. It's perhaps pretty as an aspiration, but there was a heated debate about whether students retained meaningful constitutional rights within the school. Justice Fortas, it offered a real leap forward in that Justice Fortas made clear that students exchanging ideas on the topic of the day is not a distraction, but instead is a vital part of the educational process itself. And you can hear Meiklejohn as informing this analysis here. Fortas says, "Our Constitution says we must take this risk, and our history says that it is this sort of hazardous freedom, this kind of openness, that is the basis of our national strength and about the independence and vigor of Americans who grow up and live in this relatively permissive, often disputatious society." You can hear the notion that we Americans like to mix it up here, and that it would be illegitimate, Fortas says, to turn our schools into enclaves of totalitarianism. As I say, there was a vehement dissent in this case written by Justice Hugo Black. Typically, when justices dissent, they simply sort of published their views in the US reports. Justice Black took the unusual step of delivering his dissent from the bench. And he spoke for more than 20 minutes. And he said during this, "I want it thoroughly known that I disclaim any sentence, any word, any part of what the Supreme Court does today." He says that we're entering a new revolutionary era of permissiveness in this country, right? There are men with long hair, for crying out loud, you know? The world really is going to hell in a handbasket. There were a lot of concerns, right, that the unrest that was happening on college campuses, thinking about, say, Columbia and Students for a Democratic Society, was going to filter down to our elementary and high schools, right? And so there really is a great deal of fear here. Black got really worked up. He was fairly frothing at the mouth, so much so that Chief Justice Warren said, "Old Hugo really got caught up in his jockstrap on that one." And if he did get caught up in his athletic supporter, many people say it's an event from his personal life. Hugo Black had a grandson who produced what back in the day was called an underground newspaper that was really critical of school administrators, and they suspended him for it. And Justice Black wrote a letter to his daughter-in-law saying, "Personally, I think the school has done exactly the right thing. The time has come in this country when it must be known that children cannot run the school which they attend at government expense," right? And this sort of logic did inform his opinion as well. He says at one point, in offering the thin conception of citizenship, Justice Black says, "School discipline is an integral part of training our children to be good citizens, to be better citizens." Pay attention, right? Mind your P's and Q's when you're in school, and then you will be able to articulate your views. So listen, this is an irresistible anecdote from Justice Black's personal life. For those of us who write about Tinker, I include it in my book. But it would also be severely mistaken to view this as merely one elderly grandfather's sort of fit of pique. Instead, it seems to me that Justice Black's views resonated more deeply with Americans than did Justice Fortas's view for the majority. I found polling data that said that a majority of respondents thought that students should not have the right to protest in school. This poll, it's a Harris poll, decided contemporaneously with was issued contemporaneously with the Tinker decision in 1969. I also found a Gallup poll, and the #1 issue confronting schools, according to respondents, was a lack of student discipline. And you can imagine that this sort of protest would be identified as a lack of student discipline. I want to emphasize here that Tinker did not emerge from whole cloth. There's a civil rights origins of the Tinker opinion. And here I'm drawing on the work of Professor Bowman. There was a case out of Philadelphia, Mississippi that was decided a few years before the Tinker decision. Mavens of civil rights history know Philadelphia, Mississippi for exactly one thing. This is where 3 civil rights workers were slain: Cheney, Schwerner, and Goodman. And in 1964, their bodies were discovered. And, and 1 month after their bodies were discovered, there are students who wish to wear SNCC, Students for a Nonviolent Coordinating Committee, buttons to school that read "One man, one vote." These civil rights workers were attempting to register black voters. And there are black students who wish to wear these buttons. They called them freedom buttons. And the principal got wind of their, trying to wear these buttons, and sent a letter home to the parents that says, "This is to inform you that your child has been suspended from school until you can come and have a talk with me. It is against school policy for anything to be brought into the school that is not educational." The temptation today is to think that this is maybe a white principal who's trying to be an opponent of racial equality. But many of you know that this is an all-black school, and this is a black principal who's sending this letter home. And it is suggestive that this was an incredibly hot topic in Mississippi, in Philadelphia, and everywhere else in the South in the mid-1960s. And so perhaps the rule that's handed down here, which says that this principal exceeded his authority, but maybe it didn't go far enough in offering protection to students' rights. It's this decision that informed the Tinker decision, and the Tinker test that's handed down says if a principal or an undereducator has a reasonable fear of a substantial disruption, then it's permissible to punish the student for the speech. A reasonable fear of a substantial disruption, then it's permissible to punish the student for the speech. But the Vietnam War was a hot topic, and people really mixed it up in December 1965 in Iowa. And certainly those who were making claims about racial equality in Mississippi, that had the ability to really get people riled up. And you could imagine the principal feeling unsafe with knowing that these sorts of statements existed. And so it seems to me that this offered too thin a protection to student speakers, and that we should have gone further still. We can talk more about that in Q&A if you'd like. So first we have the Barnette and the Tinker decisions, and these are two wonderful decisions. They didn't go far enough, but wonderful decisions, two victories for student speakers. And then there were several decades where things sort of went off the rails, and the thin conception of citizenship rises to the fore. The first of these cases is a case from 1986 called Bethel versus Fraser, where a high school senior gives a nominating speech to a friend of his for the student council, and it is an elaborate sexual innuendo. He doesn't use any swear words or anything of that nature, but it's an elaborate sexual innuendo suggesting that if his candidate is elected, that he will stand firm, for the student body, emphasis on the word firm and things of that nature, okay? He says that he was inspired by Three's Company, the television show that I certainly watched in my childhood, which most of the plots featured sort of improbable sexual innuendo and mix-ups and everything. And he says, Fraser does, I was victorious. My candidate won more than 90% of the votes. Therefore, mission accomplished. This is a case where Justice Hugo Black strikes back. Whereas in Tinker, Justice Fortas's focus on sort of our relatively open, often disputatious society, here, Chief Justice Berger writes an opinion, and the emphasis is not on people mixing it up, but instead on civility and manners and decorum and etiquette. And they found that Matthew Fraser's speech was not protected and that it was permissible to suspend him from the school. And Chief Justice Berger is channeling Justice Black, the dissenting opinion from Tinker, and indeed he cites Justice Black. He says that schools have a responsibility for inculcating the habits and manners of civility and teaching the students the boundaries of socially appropriate behavior. Excuse me. It's an interesting question as to whether we should regard this as protected speech, this lewd speech. The Fraser decision handed down an exception to the Tinker rule that says if it's lewd speech, then it's permissible to punish the student for the speech. But how lewd this speech actually was is an open question. After all, the New York Times reprinted the speech in full. The famously prudish New York Times reprinted the text of Matthew Fraser's speech in full, and maybe more importantly, the school newspaper reprinted this speech in full. So if it were truly so scandalous, it seems to me that they wouldn't have printed it. The next case I'll talk about is one that was decided when I had the great good fortune of being a law clerk at the Supreme Court. This is a case that's formally called Morse versus Frederick. It was decided in 2007, but nobody calls it Morse versus Frederick. Instead, everybody calls it Bong Hits for Jesus. It's this slogan that was written on a 14-foot-long banner that a high school senior, of course a high school senior, unfurled across the street from the school. Many teachers released their students from class in order to witness the Olympic torch making its way down Glacier Avenue in Juneau, Alaska. and Joseph Frederick unfurls this banner with some of his buddies. The school principal sees the banner, marches across the street, snatches the banner out of his hands, and then suspends him for 10 days. And it's an open question as to whether this was protected. It seems to me that here, too, we see the thin citizenship notion prevail. We can understand Fraser is saying he deserved to have his mouth washed out with soap, and while we can't do that, you know, we don't have to stand for this. And Chief Justice Roberts' opinion for the court in Bong Hits for Jesus says, in effect, we don't have to stand, and teachers don't have to stand for, you know, high school seniors acting a fool, you know? You gotta fit in, pay attention, pull up your socks, young man. The rule that Chief Justice Roberts hands down is an unusual one in the First Amendment. The rule that he says is, if a principal or another educator reasonably believes that the speech in question is designed to promote illicit drug use, then it's permissible to punish the student for the speech. That's unusual from a First Amendment perspective, because the First Amendment typically requires viewpoint neutrality, right? You can't say that it's the viewpoint that you are articulating that makes it permissible to punish. And so you would have to, at a minimum, silence both sides of the debate. But here, Chief Justice Roberts says, we have an enormous problem with drugs in American society, and high schools are the locus of that problem, in effect. And so it's permissible to silence pro-drug speech, even though anti-drug speech is welcome, right? You can imagine students wearing Students Against Drugs and SAD and all that sort of stuff and everything, right? But they have silenced one side of the debate, and that prevents the marketplace of ideas from being able to function properly, at least according to Meiklejohn sort of style notion of a robust freedom of speech. Justice Stevens wrote a dissenting opinion. I admired the dissenting opinion when I was a law clerk, and I admire it all the more today. Justice Stevens was quite elderly at the time in 2007, and he said, I can remember from my days of my youth debates about prohibition. And the force of the analogy to the prohibition of alcohol is that what is illegal today can become legal tomorrow, and the way that that process works is by people announcing their dissident views on drug policy. And it was a powerful argument in 2007, and viewed through modern eyes, it seems to me that the point is all the more powerful because we have witnessed a transformation in our legal landscape when it comes to marijuana laws. There are a majority of states that now have either decriminalized or even legalized marijuana. And so the court, in my view, got it wrong, and it's partly because of this thin conception of citizenship that animated the decision. The next case is the one where I depart from liberal orthodoxy. Don't take back my degree or anything like that, okay? So this is a case called Hazelwood versus Kuhlmeier, and it's decided in 1988. It's a case involving a school newspaper. And this is in St. Louis, Missouri. And the school newspaper student authors wrote a couple of different articles that drew the attention of a high school principal who was reviewing the document before it was meant to go to the printer. The two articles in question involved divorce and teenage pregnancy. And the principal said, well, there's a student quoted in the divorce article who says that her dad was out playing cards with his buddies, and they named the student, and they should have given him an opportunity to respond. This is sort of bad journalistic practice. And then the article on teenage pregnancy was meant to be anonymous, but there were sort of revealing details that let everybody know who these young women actually were. And really, we're talking about not just teen pregnancy here, but teen motherhood. A number of the women had given birth. And so the principal said, these articles don't pass my test, and therefore I am going to pull the articles. He didn't tell the students that he was going to do so. The issue of Spectrum, the school newspaper, was meant to be 6 pages. The students go to pick up their copies of the newspaper, and it's 4 pages instead. The middle insert had just been yanked. This principal, in my view, demonstrated horrific judgment. In my book, I say that it was a parade of spectacular ineptitude. There are many different ways to handle this. You could anonymize the quotation regarding the student whose parents were divorced. What topics could be more important for a school newspaper than talking about divorce in the 1980s at a time when divorce is skyrocketing? And there are these heartbreaking quotations from students who say, I thought it was my fault when my parents got divorced. In the article involving teen pregnancy, a number of the women are saying, I didn't think I could get pregnant the first time, right? Like these sorts of misconceptions. What topics could be more vital? And if you're going to do it, you need to have a conversation with people ahead of time. He says the school year was running out, and it was either publish the 4 pages or none of the pages at all, and so this was the best that I could do. If it were in my power, and I were the superintendent, I would figure out a way, trying my best, to reassign this principal to other duties. This seems like very, very poor judgment. So I'm not trying to sort of vouch for the principal by any stretch of the imagination. And yet, the late Justice Scalia once said that new judges should be issued a rubber stamp that reads, stupid but constitutional, right? Terrible idea, but constitutional. And it seems to me that the principal's behavior deserves to be embossed with that statement, stupid but constitutional, because if you import First Amendment doctrine into the area of the school newspaper, some oddities will arise. We should understand, I believe, the school newspaper as being a type of government speech. The government speech doctrine did not exist, but the basic idea is that when the government speaks, it gets to decide what it wishes to say. And so if we were to import the First Amendment into this arena, then it would transform routine journalistic practices into constitutional violations. After all, as I told you, and as happens at just about every school newspaper, the principal or another educator is going to review the documents before they go off to the printer, and we can understand the principal or another teacher as serving as a type of editor-in-chief. But that, under First Amendment doctrine, could be regarded as a type of prior restraint, where the government is not allowed to sort of review things ahead of the speech happening, because otherwise the fear is that people will engage in self-censorship and that it will chill protected speech. So we can understand that as, prior restraint. It's also true, as I've already mentioned, there's a notion of viewpoint neutrality. But what would that look like in the context of a school newspaper? Right? I mean, the Spectrum surely, like many school newspapers, would say, we're going to run an editorial about why we should triumph over our crosstown rivals in the big football game. But if somebody wants to write an editorial or a column saying, no, we should actually lose our game against our arch rival, then it would be sort of constitutionally required to run that newspaper. That can't be right. That is a downright bizarre conclusion. The other thing to say is we need to think about the freedom of the press here, in addition to thinking about the freedom of the speech. The freedom of the press, it's often said, belongs to the person who owns one. And so we should think about the freedom of the press as attaching to the private individuals, like the Salzburgers with the New York Times, and not think about, within the government itself, but the private sort of press entity as enjoying freedom of the press as against the government. But when both entities are part of the government, it becomes odd. Imagine that during the Watergate era, Woodward and Bernstein went to Bryn Bradley, their editor, and said, we're ready to run the articles on the Watergate affair. And Ben Bradley says, you don't have it. And then they say, well, you violated my free speech rights. That is sort of an incoherent idea and an unsatisfactory one. So it's for these reasons that I believe that the court got it right in Hazelwood versus Kuhlmeier, even though I suspect that many believe that, that the court botched it here. I think they reached the right result, even if they got there for the wrong reasoning. One little sort of pro tip here is that it's often a mistake for schools to censor speech. What happened in this case involving school newspapers is that the St. Louis Globe-Democrat got wind of the newspapers, and they ran the articles under the headline, "Too Hot for Hazelwood." So they succeeded in gaining more attention than they otherwise would have received. It's also true that students do have a number of areas that are open to them, and they can, express themselves in lots of other ways. Okay, last case that I'm going to talk about in earnest, and then I will look forward to your questions, your comments, and your objections, is a case of recent vintage. It's called BL versus Mahanoy Area School District case. It's from 2021, and this is the curious case of the vulgar cheerleader. There was a student who was at an off-campus location at a convenience store on a Saturday afternoon. She was hoping to make the varsity cheerleading squad. She was instead demoted to the junior varsity cheerleading squad, and she's incredibly frustrated. And so, like all of us, she takes to Snapchat in order to vent her frustration, and she writes a message that says, among other things, "Fuck cheer." The internet, as I try to impress upon my daughters, never forgets. And so somebody took a screenshot and showed it to one of the coaches, and she's dismissed from the junior varsity cheerleading squad for the year. And the question is, in effect, what does the freedom of speech mean outside of the schoolhouse gate, especially in the age of the iPhone, right? These are very sort of complicated questions that are involved here. Students had not prevailed, high school students had not prevailed in a free speech case since Tinker in 1969, when the BL, the Brandy Levy case, made its way to the court. And many people thought this was going to be a loser. After all, she wasn't suspended from school. She was merely demoted to the junior varsity, suspended from the junior varsity cheerleading squad. And so people thought there's no way she's going to receive protection. She did receive protection. My old boss, Justice Breyer, offered the robust conception of citizenship. He says, "Public schools are nurseries of democracy." Beautiful line, one of the most memorable that he ever wrote during his time at the court. He said, "Our representative democracy only works if we protect the marketplace of ideas." And here you can see that is the thick conception of citizenship, but Justice Breyer's majority opinion also at times voiced the thin conception of citizenship. He says that there was no evidence that the school evinced any general sort of effort to police vulgarity outside of the classroom. But suppose if they did evince that habit, they would do basically nothing other than punish students if you're punishing people for saying the F word and everything. And he also said that, well, the student here, it's okay to protect this speech because she didn't identify any of the school in her posts or target any member of the school community, with vulgar or abusive speech. But of course, many young people are finding their voices speaking out against the governmental authorities in the place of the schools. And so I think that this opinion offered insufficient protection to free speech. Okay, so why do any of these topics really matter? Well, for a few reasons. One is that it seems to me that there is a misapprehension of many students' rights. If you follow this area closely, you see lots of teachers are unaware with the basic precepts that I've laid out today. It seems like a week doesn't go by where a teacher tries to discipline a student for refusing to pledge allegiance to the American flag, something that is very prominent these days as a result of being inspired by Colin Kaepernick and his kneeling down. That is a plain violation of Barnette. And one of the things I was trying to do in my book was to explain these legal concepts in a clear way that even non-lawyers could understand, so that it would raise awareness of our constitutional rights and that it would minimize these sorts of things. I also think this is important because there's work to be done in this area. As I told you, the test from Tinker, that's the default mode, is whether there's a reasonable forecast of a substantial disruption of school activities. This is, as I say, it was a step forward, but we should be farther than that now, because this test can be understood to bake in what First Amendment mavens would refer to as a heckler's veto. This is a term from the great Professor Harry Calvin of the University of Chicago, who says, in effect, that sensitive listeners can, if they object vociferously enough, shut down otherwise legitimate speech. And given the reasonable fear of a substantial disruption, it leads to people saying, in effect, and excuses people saying, I'm going to beat you up because you said something that I don't like. And we should resist this heckler's veto. There's a wonderful district court opinion from right here in the great state of Rhode Island involving a student called Aaron Fricke. This is in the early 1980s. Aaron Fricke wishes to bring another young man to prom as his date. And the school gets wind of this, and they say, we've had, pushing in the hallways and sort of disruptions about sexual orientation, and therefore, in order to keep the peace, you're not going to be able to bring a young man to prom as your date. And the district court opinion in Rhode Island says, in effect, nonsense, that to allow those unruly sort of, students, the mob, to call the shots here is a violation of the freedom of speech. Fricke wishes to express his sexual orientation through his person who he's going to bring, and you need to protect that free speech right. It seems to me that that is a much stronger approach. And there are some instances where the courts have not been receptive to these arguments, including in a case where students wish to wear the American flag. We can talk about that more in Q&A if you wish to do so. One other reason that it's important for me, in my view, to be talking about these cases is I'm concerned that respect for free speech among young people is on decline. And I fear that that is especially among my people, the liberals, those on the left. And one of the reasons I wanted to highlight the Tinkers and the Barnettes and Philadelphia, Mississippi, is to say that liberals should avail themselves of the freedom of speech. That for a long time, the idea was that the liberals were deeply invested in vindicating free speech rights. And these days, when I look at cases, I'm often encountering speech, what I would associate with on the right. Anti-gay speech, Confederate flags are a common case in this area. And many liberals subscribe to this notion that freedom of speech is just a method that the powerful use to harm the powerless and the marginalized in our society. I think that is a mistaken view, and that it is especially important for those of us who wish to promote unpopular ideas that we need protection for that to happen. Otherwise, the Tinkers, it would have been permissible to shut them down. They were offering a minority viewpoint, and it's important that the courts protected those, and we need, as liberals, in my view, to become more enamored of free speech. Some of you disagree with what I've said today in my notion of the robust conception of citizenship and think that Justice Black had it right and that we've gone off the rails and we offer students too much protection. And if you are one of those people, don't worry, you have company in high places. Justice Clarence Thomas, in the Morse versus Frederick decision, said that he thought that Tinker was wrongly decided, that we took a wrong turn there. And he sort of has originalism, and he says, you can hear him pining for the good old days. He says, teachers managed classrooms with an iron hand. In the earliest public schools, teachers taught and students listened. Teachers commanded and students obeyed. Teachers did not rely solely on the power of ideas to persuade. They relied on discipline to maintain order. Now, that makes my heart sing as a professor, but I'm not sure that that's exactly where we want to be in our world. That's a joke, obviously. It's not just Justice Thomas. There's also Judge Richard Posner, one of the towering legal figures of the post-World War II era. He's one of the most revered people that we have. And here's what he said in a speech that was decided about 15 years ago. He says, sort of channeling Thomas in some respects, a heavy federal constitutional hand on the regulation of student speech by school authorities would make little sense. The contribution that kids can make to the marketplace in ideas and opinions is modest, he says, right? So Posner's revered. In my view, his colleague, Judge Alana Rovner, got much the better of the argument in this case. She wrote an opinion for herself, and it's with her words that I will leave you today. Here's what Judge Rovner has to say. Youth are often the vanguard of social change. Anyone who thinks otherwise has not been paying attention to the civil rights movement, the women's rights movement, and the anti-war protests for Vietnam and Iraq. The young adults to whom the majority refers to as kids and children are either already eligible or a few short years away from being eligible to vote, to marry, to serve in the military, and to be tried as adults in criminal prosecutions. To treat them as children in need of protection from controversy is contrary to the values of the First Amendment. Thank you.
Thank you very much. We'd love to take questions. I know we have mics for the recording, but if you don't want to get up, I can repeat the question as well. So who would like to go first? And you're not going to be graded, so there shouldn't be any hesitation. Yes, yes, ma'am.
About the divorce and the pregnancy, do the students know that they were going to be in the newspaper?
So the question is, in terms of that case that dealt with articles about divorce and teenage pregnancy, did the students know that they were going to be in the newspaper?
Great question, and yes, my understanding is that the students who were interviewed by the journalists were aware that they were going to be in the newspaper. And I should also say that I am skeptical of the idea that the real motivation here was concern about preserving the anonymity of the students who were pregnant, because as I say, these students were not merely pregnant, but had delivered children, and that's a rather difficult thing to keep a secret and everything, right? And so
They may not want to discuss it in the newspaper and get into judgment from their peers, you know what I'm saying? I mean, it's just, the whole
Yeah.
privacy thing is what I'm wondering about.
They were cooperating with the students who were interviewing them, and the form that they took were long first-person accounts of here's what happened, here's how I got pregnant, here's the reaction from my parents, and here's how we're working it out and everything. So this was not a sort of sneak attack or an expose or anything along those lines. Although your question is a very helpful one about how much room would we want to allow students who are on the school newspaper to sort of, run wild with. You could imagine some students as offering critical assessments of their other students, and we ought to be, in my view, sort of careful about that because, when it takes the imprimatur of the school, and there is a school of authority figure who's in the background here, it seems to me that that's a particularly sensitive matter.
Yes, sir.
I have a question. My name is Breyer. I'm a senior studying business and public policy. First of all, thank you very much for being here. In regards to just kind of policing language, right? Some of us are international students coming from cultures where I would say there isn't enough, consciousness when it comes to social issues in regards to how we see certain things. And then you come to a place like Brown where it's a lot of, consciousness when it comes to politically, being aware and all these things. And, mind you, some of us are coming from backgrounds that, we trying to feed our families, right? We don't really kind of pay attention in terms of how we express our words kind of affect other people. And you come to a place like Brown where I would say it's a very unforgiving place where you go to class, you say something that doesn't fit what somebody's feelings or emotions, they kind of weaponize that against you. Whether that is in a way where they're going to address that through, like in a social way, where they will separate themselves from you. I'm just saying that, just kind of summarize the question. Like, how can colleges make these spaces kind of, I would say, more safe spaces, but I understand that the safe spaces is kind of defined by the dominant culture. Right? I don't think there is something that is absolute, like safe space. You know, so it's just like I'm here now, and sometimes I'm having interaction, and it's just like I'm always thinking about the words, like how's this person gonna feel, and in a way you don't even want to interact with people, right? And now I'm moving away from here, and it's just like, what was the purpose of this humanities degree?
So I think to summarize very eloquent comments and questions, do these principles that you've been discussing that have mostly been applied to K, let's say K through 12, how do they apply in the college environment in terms of the protection of free speech, and what's the governing entity? You're saying that it's basically a social construction that monitors your speech. So what is the governing body of higher education, and how do we manage that, especially with the difference between government state schools and private schools at the college level?
It's an important question and an important set of comments, and I'm grateful to you for articulating them. I am, like you, I hear, concerned about the climate on some of our campuses in higher education. And you asked about what can be done. I think of the classroom as it being an important place to be able to make mistakes and to try out ideas and to get feedback on those ideas. One thing that I am concerned about that exists in many law schools and undergraduate environments is the recording of classes, where I don't think that is actually sound as a pedagogical matter, where students need to be able to try out ideas. And in my own instances, I'm worried about students saying something in a class, participating. I will frequently say, what's the strongest argument for this case, even if it's not your own idea? And I shudder to think that someone in their Senate confirmation hearings 2 decades from now, something could be sliced up and to say this person, supported abortion or opposed abortion. And so that's one thing that it does seem to me that it's important to sort of protect the place for people to be able to make mistakes. It's an interesting idea about the shunning and certain ideas being stigmatized. Some people would say that's the marketplace of ideas functioning effectively, right? That people should be graceful with each other, but there are some statements that are constitutionally protected, but sort of beyond the pale and everything, right? And that one way that people let folks know that their comments are beyond the pale, is by saying, we disagree. And that would be better, it seems to me, than just sort of literally turning your back. So these are really important issues. I should also say, as Professor Schiller suggested, that we're often thinking here about, when you're talking about constitutional protections, at least narrowly defined, we're thinking about the public entity censoring speech as distinct from a private entity, where overwhelmingly the Constitution of the United States binds governmental entities and everything. And so as a formal matter, the Constitution wouldn't have anything to say about this in this matter involving private universities. But that doesn't mean that there aren't larger sort of animating principles about the free exchange of ideas that are foundational to a university setting. So these are absolutely very important matters.
Yes, I'm going to take on one quick, is that when you were at Brown, there were several major controversies about protection of free speech that also in the early aughts at Brown, very high profile disputes and conversations. And so it's very difficult to manage, I think, particularly in a private college setting. I have a question here and then a question there.
Russell's old expression of Florida, 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 being all the news now. Thinking about this problem from 2 levels, right? From the secondary school level, and then what's actually being proposed at the level of the state-controlled university levels. The governmentally led move to shape curricula at the secondary school and primary school level in ways that students, and particularly the focus is on white students, are not being exposed to various types of critical race and other content. The claim is content non-neutral perspectives on American legal and racial history that quote unquote make white students feel bad at that important developmental level of their psyche and their sense of social responsibility. The state's ability to act as both censor and shaper of what is perhaps not content neutral at all perspectives on the truth about American history, and excluding other points of view that might be more critical. The power to do that at the primary and secondary school level, part A. The ability to do that at the university level, the college level, for both state-owned and state-controlled universities under the Board of Regents to actually shape curricula like getting rid of Black studies or limiting or making sure that nothing like critical race is taught. I'm just curious about the nature of the claimant, because there are discussions now about students actually suing at the high school and primary level, claiming that some type of deprivation of civil rights related to freedom of speech and racial identity is going on there. How that works, granted that, first of all, there's no constitutional right of education. We'll set that aside for a second, fundamental right of education. But the fact that, you know, the legislature is effectively exercising its control in a way that has not been effectively legally challenged. Then secondly, the university prospects, which you
So to summarize,
because that's the second part of the plan, right?
To summarize the question is just to summarize the questions are sort of what is the scope of constitutional purview that what rights do these students have to say that you're, by not letting me learn these things, you're denying me my free speech. Yeah, but I have to move on because we have a lot of people who want to ask questions. So I want Professor Driver to answer your question. And then again, at the college level, are there any constitutional scope of power?
Okay,
rights?
so it's a great question thinking about, you know, Florida and what's happening there. There's a lot of attention that has been paid to what people refer to as anti-CRT legislation and things of that nature. CRT meaning critical race theory, of course. And this is an uphill battle, is the truth of the matter, from a legal perspective for those who wish to challenge these sorts of laws. Maybe I should back up for a second and say I think these laws are deeply misguided and opposed to intellectual inquiry and are emblematic of the sorts of censorship and suppression that is an all too prominent feature of American society. I put my lawyer hat on just a little too quickly there rather than keeping my citizen hat on for a second. The reason that it's an uphill battle from a legal perspective is that typically states and localities are able to control curricular decisions for themselves. And lots of challenges have been rejected from religious groups saying, when you make this assignment happen, it's a violation of our free exercise views, and the courts have been unsympathetic to these sorts of claims. That doesn't mean, however, that all hope is lost from a legal perspective. It seems to me that the most profitable way to go here would be to bring what lawyers would refer to as a void for vagueness challenges for the reason that your very perceptive question identified, which is to say that when you speak about these very loosely phrased things about people feeling badly or you've made people feel uncomfortable, it may be uncertain as to what the teacher has said that results in discomfort or unease on the part of students. It's very hard to know what would actually be driving that. And so, that seems to me to be the most helpful way to go, in part because the basic idea of void for vagueness is if you don't know that you are at risk of violating the statute, then it's impermissible to punish you for that statute. So it seems to me that that is where the action is likely to be in this very important area.
Could you just, get to your questions, can you just clarify a little bit more about what you just meant? Meaning, so who are the actors there that would not know about the statute?
I would think that the actors would be probably actually the teachers who would bring these sorts of claims to say, you know, I'm interested in teaching about things that even the opponents of critical race theory would not have a problem with. People don't think that, of course you should be able to teach about slavery. How are you going to have a course on American history or on the Constitution of the United States without talking about, you know, the 13th Amendment and things of that nature, right? But that conversation could lead to feelings of discomfort on behalf of some students. And so the teacher could be held vulnerable for violating the terms of the statute, even though that should be constitutionally protected. And so I mean to suggest that it is the uncertainty of the behavior that is meant to be prohibited that would yield sort of legal uncertainty, and therefore a court may seize that to invalidate these things as being excessively vague in the conduct that's prohibited.
And I'll take your question, Donnie, 1 second. There's also folks at Brown, scholars at Brown are doing work to point out that on average, between 51 and 55% of students in K through 12 are self-identify as of color. So when we think about who's being denied this education, it's a combination, but it's also students of color and then white students. So it's really important to recognize how many of these districts are not being served educationally in that way. Donnie.
So there's been a bit of a personnel change at the court in recent years, and I'm not going to ask you to make a prediction, but has any justice, you know, signaled, or, you know, either in recent decisions or in lower court decisions, that they do have a different conception, maybe a thinner conception of citizenship? And do you, like, I don't know, are there any maybe cases that indicate that?
It's a very, oh, sorry, pardon me.
So for the record, so the question is, of the new justices on the court, have any of them signaled what their views on thin or thick citizenship are?
We are at a time of quite rapid turnover at the court. One thinks about the recent justices, including Justice Jackson, and before her, we're thinking about Justice Gorsuch and Kavanaugh and Barrett, right? So there's been quite a lot of volatility here. The Brandy Levy case, the one from 2021, was a quite lopsided decision. And that is to say that the recently appointed justices that I just mentioned, save Justice Jackson, who was not yet on the court, joined Justice Breyer's majority opinion. And I'm especially grateful to you for asking about this, because there were moments when I was writing my book on these topics when I thought that my old boss, Judge Garland, was going to become Justice Garland. And those were especially sort of fun chapters to write. I certainly would not purport to speak for Judge Garland, who certainly makes up his own mind on these sorts of questions, and all questions for that matter. But I was hopeful that the law might move in a more hopeful, in a better direction from my vantage point. Nevertheless, that does not mean that all hope is lost in this area. And one of the moves that I make in the book is to suggest that it might be possible to cobble together a coalition of liberals and the libertarian-inflected vision of constitutional law that is ascendant in some right-leaning circles to bring about relief in this area. And the areas that I identify in the book are the freedom of speech, right? If you're a libertarian, you're skeptical of state authority, and you want people to be able to speak their minds without worrying about sort of government censorship. And that would, and so arguably the Brandy Levy decision, and you know, those justices joined that, sort of underscores this point. Justice Gorsuch in particular has enunciated sort of libertarian ideas associated with the Constitution. And I'll just quickly identify two other potential areas where liberals could join together with libertarians to bring about some relief. And that involves the Fourth Amendment's prohibition on unreasonable searches and seizures, where there are these suspicionless drug searches, where an exchange simply for participating in an extracurricular club or playing on the softball team makes you have to succumb to giving a urine sample for drugs and everything. And if you're a libertarian, that should make you want to jump up and down and scream that a government official can require that matter simply in exchange for participating in extracurricular activities. And then the other issue is the Eighth Amendment and the prohibition on cruel and unusual punishment. And I'm thinking about corporal punishment, which still exists in this great nation of ours. That issue is maybe the one that I care the most about in the book. Before I started examining this material, I was unaware that public school students were being struck with foreign objects for things like sitting in the wrong seat or being late to class. People were being hit with 2x4s. I write in my book about James Ingram, who was struck more than 20 times for being a little slow to get off of a stage at a junior high school. He was hit with such force that he could not sit down without experiencing discomfort for 3 weeks. He missed 2 weeks of school. A doctor prescribed pain relievers and cold compresses and laxatives. I found a doctor's notes. This guy, James Ingram, goes to a doctor. All that's prescribed. He returns 3 days later. He's in such agony. The doctor noted that he had a bruise that was 6 inches in diameter, that was tender, purplish, and oozing fluid. You might think this would be an easy case for the Supreme Court of the United States and say, this violates the prohibition on cruel and unusual punishment. The majority opinion said, nope, not even punishment for purposes of the Eighth Amendment, because the punishment that they had in mind meant punishment stemming from a criminal conviction. James Ingram wasn't convicted of anything, therefore, have at him. So the idea that corporal punishment exists in this great nation of ours in the year 2023 is an abomination. And we need the libertarians at the court to see the cause, because the idea that the government can exercise dominion over a student in this fashion is nauseating. And I say that the Supreme Court needs to get involved because I fear that the jurisdictions that retain the practice at this late date are not going to eliminate it on their own.
I have,
Right, yeah. The question was about, isn't that assault? And one might think so. There are actually some provisions in some states that expressly say that if corporal punishment is being administered, that it is not sort of child abuse or anything. So there's an express statutory carve-out in this arena. And I share your sense of, recoiling at these horrible facts that I have laid on you all just before the dinner hour.
You raise your hand and then you. Yeah.
This question that your project seems to raise of where free speech begins. And it seems like a lot of your examples, I'm not sure, I don't have a legal background, are taken from high school. So I'm wondering about what the kind of constitutional landscape of free speech looks like in middle school and elementary school. Whether a 5-year-old has different free speech rights from a 12-year-old, and whether the law manages the kind of transition into free speech. And kind of going off of that, what the intersection between constitutional law and child development is for your book.
These are excellent questions. What's the scope of constitutional protections for kindergarten and K through 6, middle school, elementary school, and then what are the intersections or divergence in constitutional scope and domain and childhood development?
Great questions, really perceptive. The Supreme Court of the United States, believe it or not, has never answered whether high school students have more robust protections when it comes to free speech than elementary school students. And I am sensitive to the thrust of the question, which seems to suggest that's a logical thing. There are some lower court cases that have said, wait a minute, this kid was in the 2nd grade in effect. And there's one particular case where a student was outfitted by her parents with a t-shirt that said something like, basically a version of, this school is racist. And the court was made uneasy by this and sort of said, well, this is the parent speaking. That's an interesting question, though, because the Tinker case itself might be regarded as the children sort of parenting the parents. And we might also regard the students who are not protesting the Vietnam War as sort of parroting their parents as well, to say, well, if your country's in a war, then you better, love it or leave it and everything, right? And so it gets a little complicated in this area. So you asked about also these sort of larger questions. Typically, minors have free speech rights that are coextensive with people who have reached the age of majority in non-school settings, which is why I'm careful to speak about students' constitutional rights rather than kids' constitutional rights, as Judge Posner did. That's inelegant and sort of imprecise phrasing, because when students are, a junior in high school is in the public park across the street after school, he has the same rights that people who have reached the age of majority. There are a few exceptions there. There's something called a variable obscenity statute, which, which deals with why it's, you need to be a certain age to purchase, say, pornographic materials and things of that nature, and why it's okay to say you can't buy that if you're too young. But that is highly exceptional. We are thinking about these issues, and there could be a coming crisis in this area of students' constitutional rights. That is to say, there's this big body of students' constitutional rights that has been articulated over time, involving a whole host of constitutional protections. More recently, paying attention to sort of adolescents' neurological development in the criminal realm, there's been some claim to say we cannot hold a 17 or a 14-year-old criminally culpable in the same way that we do reach, that we hold people who have reached the age of majority. And the reason that they say this is attributable to the adolescent brain. There's work by a researcher called Lawrence Steinberg, who says that the adolescent brain is like a little bit like a car that is equipped with a really sensitive gas pedal and really terrible brakes, quick to anger, hard to slow down once you're there and everything. And so they've done that, the court has, in order to say we're not going to hold people culpable for sort of, capital crimes and things of that nature. But you could imagine those cases involving criminal culpability as eventually being used to unsettle some of these students' constitutional rights. And people might say, well, why are we allowing students to be able to express themselves in such, robust fashions and all of this sort of thing? And so that is one area to sort of keep an eye out for.
Yes, sir.
Yeah, so my question is how to think about people who push the boundaries or seem to push the boundaries of free speech in order to either go viral or profit off of their speech. So a couple examples would be people on social media who seem to understand that if they phrase their thought in a specific way, they know that they'll go viral, even if they could express it in a more diplomatic way. Or a more recent example is with Fox News, we seem to know now that they were, there was a disconnect between what the journalists believed and what they were saying, because they knew that if they said certain things about the election, they would retain their viewers. So it kind of adds this interesting dimension to free speech about authenticity of belief, and I'm curious how you would navigate that.
So the question is, do the bounds of free speech, that we enjoy the protection of free speech, but do we have a responsibility to be authentic in our speech when we're living under the umbrella of free speech? It's an excellent question. I'm going to let the audience know that will be our last audience-generated question, and then I will not let Professor Driver leave without commenting on the prospects of the case concerning affirmative action that's before the Supreme Court to be decided this year. So that'll be our final question. Yeah.
Okay, so thanks for the question, thinking about authenticity and people trying to get traction and eyeballs, especially prevalent on sort of social media and things of this nature. It's an interesting question. We might regard Matthew Fraser as attempting to make sure that people were really paying attention to his speech, and that this is, part of what it is to speak. You want people to pay attention to you. And so the question of authenticity is an important one. One case that I write about in my book that is a complicated one, but I'm not at all convinced that the court got it right. The student was quite authentic in his beliefs. It involved anti-gay speech. This was for a day of silence promoting gay equalities, a cause that I treasure. And there was a student who wore a T-shirt to school that said something like, our school should not accept what God has condemned. Homosexuality is a sin. I detest that message, and I have no doubt that our gay brothers and sisters have suffered as a result of such messages. But I am also careful to say that it's unclear to me how this student could have expressed what I believe were his deeply held religious views in a way that would have not drawn the censorship of the schools. And we should be careful about allowing the school to censor this sort of speech. It's important to say that he did not use sort of epithets in order to express himself. His message was homosexuality is a sin. I deeply disagree with that message. But it seems to me that we need to have more protection for unpopular speech, just like the Tinkers in the 1960s and like this young man at a California high school about 20 years ago, right? This was not a popular view, and it was his authentic view, and the high school permitted this view to be silenced, and I find that a troublesome decision, even though I want to be clear that I dislike it. I hope I've made that clear. The traditional idea is freedom, for the thought that we hate, freedom of speech, right? And that the answer to speech that is disfavored is not censorship, but more speech. That's the traditional view, and I adhere to that traditional view.
Thank you. I will refer the audience, if you have a chance. Professor Driver wrote a very interesting op-ed column for the New York Times, October 26, 2022. Think affirmative action is dead, ? Think again. So I'd like to ask you just to sort of summarize the argument you make in that op-ed, and also the idea that you talk about in the article, particularly about the courts turning away from precedent, or are we over-exaggerating the extent to which the court will create new precedent and expect that to stick, but not stick with old precedent?
Yeah, thank you. So yes, I wrote a lengthy op-ed in the New York Times saying that in effect, everybody thinks that affirmative action is going to be eliminated in June of this year. There are 2 cases pending at the court involving Harvard and the University of North Carolina. And I suggested, as a descriptive matter, that the court may be inclined to give 5 more years to affirmative action, a 5-year reprieve in effect. And what motivated me to say this is that Justice O'Connor, in her 2003 decision called Grutter, involving the University of Michigan Law School, a decision that upholds affirmative action, toward the end of that opinion, she says, it has been 25 years since we first ruled on the constitutionality of affirmative action in a case called Bakke, involving UC Davis Medical School. And she says, in another 25 years, we expect that affirmative action will sort of no longer be, permissible. And I noted that Justice Thomas referred to this as a holding of the court, which is something that lawyers pay attention to, holdings as distinct from mere sort of idle chatter, what lawyers would call dicta. And that is an unusual move to have a sunset provision in constitutional interpretation. But just because it's unusual doesn't mean that the court is going to ignore it. And one potential pathway for the court to go in this case that's pending is for them to say, we are not sort of overruling the Grutter decision from 2003. Instead, we are honoring the Grutter decision by offering a 5-year reprieve. I wrote this argument before the Supreme Court heard oral argument, and they heard a lot of oral argument, and this issue of an endpoint did come up repeatedly. And so one of the fascinating things, at least to me, is that proponents of affirmative action, of which I am one, and the time of 2003, many of them thought Justice O'Connor woefully naive in her prediction about the speed with which we're marching toward the goal of racial equality. Proponents of affirmative action, really disliked that aspect of the opinion. But here we are, 5 years away from the 2028 deadline, and it may well be that this thing that was bemoaned in 2003 is the last best hope for continued vitality of affirmative action because of the question regarding the shift in personnel regarding the Supreme Court of the United States. So thanks for that really wonderful question.
Well, thank you so much for your fantastic question.
Thank you.
And we have about 5 or 10 minutes if you wanted to come up and say hello to Professor Driver, and then we'll be finished.
Thank you so much.